Hello, my name is Emily Cook, and I'm a practicing attorney and Preventive Legal Advocacy Fellow at the Barton Child Law and Policy Center at Emory University School of Law in Atlanta, Georgia. I've put this presentation together as part of my work with the Barton Center in an effort to raise awareness of preventive legal advocacy programming and its potential to safely reduce reliance on our child welfare system in the United States. My hope is to provide a comprehensive overview of preventive legal advocacy fundamentals and to answer questions commonly encountered in the PLA field. At the end of this presentation, I will walk viewers through a short exercise intended to encourage you to begin thinking about how preventive legal advocacy might be implemented to benefit children and families in your community. If you're interested in learning more about preventive legal advocacy and programs across the country currently engaged in this work, I would encourage you to reach out to me via email to join our national PLA cohort listserv. This national PLA cohort is a group of more than 150 child welfare professionals engaged in PLA and pre-petition programs. Our group meets monthly via Zoom, and in those meetings, we explore various facets of PLA program design and implementation and share resources and experience to support and improve the practice of preventive legal advocacy nationally. And with that, let's begin with the most fundamental of questions. What is preventive legal advocacy? Preventive legal advocacy is the act of supporting families and promoting the social determinants of health by addressing upstream civil legal issues that, if left unresolved, can result in unnecessary child welfare system involvement. Preventive legal advocacy is part of the continuum of high-quality legal advocacy to support child and family well-being. This graphic was put together by Casey Family Programs and sort of shows the various facets of this continuum of high-quality legal advocacy. So all of that sounds good, but what does it really mean? Let's look at a familiar fact pattern. Let's begin with a civil legal issue that should be familiar to most of us in the child welfare practice area. So, civil legal issue, our family is wrongfully evicted. A mom and 3 children are wrongfully evicted from their home and the landlord keeps the deposit. Mom is unable to obtain housing and moves to an extended stay motel where stress leads to relapse. A CPS report is filed and an investigator substantiates neglect stemming from inadequate housing and substance abuse. Following removal, mom is summoned to appear, and for the first time, she is assigned legal counsel. This fact pattern could have gone differently with preventive legal advocacy interventions. What do I mean by that? A preventive legal advocacy attorney could have stepped in and represented mom to prevent eviction. A PLA team could have applied for public housing and referred mom for treatment and children for counseling. The PLA team could have counseled mom through investigation to prevent substantiation and removal. And finally, a pre-petition attorney could have prepared a defense prior to any preliminary hearing and potentially secured a return. This is likely a familiar fact pattern to those of you in the child welfare field. Our families rarely face one problem at a time. The snowball effect is the standard, and one legal issue inevitably leads to others. I've highlighted a few key facts here, but we could add to it. Mom could have lost her job when she had to move the family to the motel because she could no longer walk to work and didn't have reliable transportation. The children likely could have missed too many days of school in the course of the eviction, and now mom could be facing a truancy summons. Mom's inability to pass a drug test could have interfered with her ability to secure TANF benefits in various jurisdictions, and now she may be struggling to feed the family. This list could go on and on. Preventive legal advocacy acknowledges the vulnerability of poverty and seeks to stop the cycle through timely legal interventions. I want to take a look at some CPS referral statistics to sort of frame out the basis for why we engage in preventive legal advocacy. It's important to understand that 1/3 of children will be subjected to a CPS investigation by age 18. 50% of Black children will be subjected to CPS investigations by age 18. 83% of CPS investigations are unsubstantiated. 1 out of 3 children living in neighborhoods with a poverty rate greater than 20% will experience a CPS investigation. These statistics, I think, reveal that we clearly have some problems in our current child welfare programming. We are reaching too many families that are having interactions with the child welfare sector, And as we know, much of that interaction can lead to trauma and a myriad of unintended consequences. So I want to move and talk to kind of the 5 common PLA program models, the types of programs that are out here doing this work. The first type of program that we frequently see, and before I get into that, let me just note, these models are not a one-size-fits-all situation. Some programs may fit neatly into one of these categories, while others will borrow elements from one category or another to create a hybrid program that meets community need. So this first grouping of what I'm referring to as community-partnered programs are sort of the grassroots programs of the PLA world. These programs are born out of a desire to meet specific need and are often pieced together over time. Community-partnered programs can be as simple as one attorney being willing to offer pro bono legal services in an effort to stabilize families, or it could be a court administrator recruiting an attorney, social worker team to start a pilot in the courthouse basement, or even a large service provider choosing to partner with their local bar association to connect families with legal advocates who can help address unmet legal needs. The common thread in these programs is their desire to serve the legal needs of families as a way of promoting the social determinants of health and avoiding unnecessary child welfare system involvement. This shared desire, coupled with a reliance on multidisciplinary approach to legal advocacy, is the bedrock of the preventive legal advocacy movement. The next type of programs I want to highlight are what I refer to as family civil legal aid programs. And these are an exciting category of programs that represent a natural extension of long-held beliefs regarding the positive impact of universal access to legal services. When we talk about preventive legal advocacy in the legal aid, legal services context, we're talking about existing legal aid offices leveraging their experience in issues like fair housing, employment law, public benefits, domestic matters, and immigration to stabilize families and build community resilience for populations vulnerable to agency involvement. This may be as simple as an existing legal office hiring a social worker to meet with clients who have children in the home and then asking that social worker to evaluate the family's needs as part of the routine course of representation. These programs often adjust the client intake process to ensure clients are asked about any CPS involvement and then have staff ready to help clients navigate the child welfare system as needed. The first steps in developing these family civil legal aid programs, is ensuring that existing legal aid offices understand that clients they serve are vulnerable to child welfare system involvement as a result of their indigent status, and then building capacity within an inevitably strained office to address that vulnerability through holistic representation. Our third category here would be medical legal partnerships. And these are arguably some of our most robust preventive legal advocacy programs. Early evidence and federal investments well demonstrate the positive impact legal expertise and services can have on individual patients. Medical legal partnerships integrate the unique experience of lawyers into the healthcare setting to help clinicians, case managers, and social workers address structural problems at the root of so many health inequities. With respect to preventive legal advocacy MLPs, program coordinators work with children's hospitals and other medical providers to ensure that pregnant and parenting mothers who are vulnerable to agency involvement have access to legal representation to address the concerns that threaten family health and safety. PLA MLPs are predicated on partnerships between medical and legal service providers and often benefit from the opportunity to tap into public health funds in addition to funding sources more traditionally associated with indigent legal rep and child welfare services. Our next category would be the child welfare law school clinics. These have long been at the forefront of preventive legal advocacy efforts. In 2009, Vivek Sankaran launched a pilot program at University of Michigan Law School called Detroit Center for Family Advocacy. Between 2009 and 2012, CFA served the families of 110 children with the goal of preventing removals. Utilizing the multidisciplinary legal advocacy model, CFA was able to safely prevent removal in 98.2% of their preventative cases, successfully reducing new entries into foster care while also demonstrating a significant return on investment for the state child welfare system. Building on the success of CFA pilot, a growing number of law schools are establishing preventive legal advocacy and pre-petition law clinics to serve families vulnerable to chronic instability and CPS investigations. Universities present a unique opportunity for the development of system-disrupting interventions, and the preventive legal advocacy field has greatly benefited from the experience of child welfare law school clinics that are leading the way in both the systems navigation and radical early defense approaches to preventive legal advocacy. Now, the fifth category of preventive legal advocacy programs is what I refer to as pre-petition extension programs. These programs are more narrowly focused on what may be considered acute advocacy. Multidisciplinary teams work in pre-petition extension programs typically work with families already known to the agency and on the verge of removal. These programs are the result of a national effort to highlight the inevitably coercive imbalance of power inherent to our existing child welfare system. Pre-petition extension programs seek to provide early access to traditional parent representation. In acknowledging that a parent's rights cannot be sufficiently protected when legal counsel is provided only after a child has already been removed from the home and a petition filed, these programs seek to provide indigent clients the same access to legal representation that someone of means might enjoy. At best, pre-petition extension programs seek to reach their clients at the outset of a CPS report, and at a minimum, they work with their local agencies and courts to ensure that parents' counsel is appointed prior to preliminary hearings so that the attorney has an opportunity to defend against removal. While agencies in many states remain opposed to these efforts to expand early access to legal representation, anecdotal evidence shows that pre-petition advocacy has the capacity to not only safely reduce the number of unnecessary entries into foster care, but can also promote better outcomes for children where parents feel less vulnerable in their early interactions with the agency and investigative case managers. So I want to take a look at common legal issues addressed by preventive legal advocacy programs. And there's several categories, and this list is in no way exhaustive, but it does cover some of the most common legal issues handled by our programs. So we see here general civil issues, including housing, public benefits, educational issues, immigration, record expungement, as well as domestic cases, including divorce, custody, legitimation, protective orders, guardianships. And then what we consider to be a little further downstream, closer to sort of our acute situations where removal is imminent. And those would be programs that are offering Know Your Rights advocacy, dealing with what we call warm lines, which is sort of an alternative to the CPS hotline report system. They work on CPS investigations, pre-petition representation, and many of them take on registry appeals. Now, most of our programs do not address all of these issues. Instead, programs may focus on broad categories of these legal issues or may just select a few specific types of cases to handle in-house. Many of our programs build up referral networks for specialized areas of the law, such as immigration or custody matters. So I'm going to move on to core elements of preventive legal advocacy. The first would be upstream referrals. Families are referred for services before there is a removal. That is kind of a bedrock, right, to preventive legal advocacy. We also utilize multidisciplinary legal teams. So those are legal teams comprised typically of an attorney, a social worker, and a parent partner, or someone with lived experience. Sometimes those are called parent allies, parent partners. There are different names across the programs, but the key is that it's someone with lived experience to provide parent support. We also deal in holistic representation. So our teams examine the full scope of family need with a prevention focus. We'll get a bit more into that. Effective community partnerships are also integral to effective preventive legal advocacy programs, right? So we need to be able to provide rapid response and warm handoffs for any needed services. Getting into upstream referral sources. This is an example of kind of the most common referral sources for our programs. I want to note that 80% of our programs accept agency referrals. And when I say 80% of our programs, let me note, we did a survey in late 2022. We surveyed the programs that are part of our preventive legal advocacy cohort, and that was about 30 programs that responded to the survey. And of those 30 programs, 80% were accepting agency referrals. Partnering with the agency has its benefits and its costs, and we can get into those. But I would note that, screen outs are a great opportunity for agency and program partnerships. Only 1 out of the 30 programs that we surveyed relied on the agency as their sole referral source. The note here is diversification is important. 90% of our programs accept self-referrals. Most of our programs rely on mandatory reporters. They're a wonderful referral source. Our programs understand that mandatory reporters may have a statutory obligation to report, but what our programs are trying to do is build a relationship and networks such that mandatory reporters place a second call to the program as appropriate. Note that the vast majority, as I noted before, 80%, over 80% of CPS reports are screened out nationwide. We know this means that there's an opportunity to reduce those unnecessary reports. And our discussions with mandatory reporters have revealed that many reporters have no idea what happens after they make a CPS report. Anecdotal evidence shows that when PLA programs take time to educate mandatory reporters about the CPS investigation process and the services offered by the PLA program, would-be reporters are more likely to call in a program referral than a formal report if they're already on the fence about a given situation. I want to take a look now at the multidisciplinary legal teams that we discussed earlier. So as we know, we have three key components to those multidisciplinary legal teams, the first being an attorney, as well as a social worker and a parent partner. The attorney provides legal counsel to the clients as well as limited legal services as appropriate. The social worker can prepare assessments, safety plans. They typically work to build clients' self-advocacy skills. They provide referrals, case management, and systems navigation. And then our parent partners bring personal experience and grounding in the community to provide support and an intimate understanding of what parents are experiencing. With this framework, the entire team works under the supervision of the attorney, allowing attorney-client confidentiality to extend to the rest of the team and often relieving all team members of any mandatory reporting requirements. We know that there are a lot of external pressures on our families. That can be from CPS investigators, from landlords, from just a variety of different sources. The primary role of the attorney here is actually to create space in many ways, to create space sufficient enough to allow the multidisciplinary team to do its job and to work with the family and provide stability. I want to note that multidisciplinary teams are cost effective. The attorneys only perform the services that necessitate legal counsel, and yet the client remains fully supported throughout the course of representation. Often, the attorney's primary function, as I noted, is simply to create space and an opportunity for the team to help stabilize the family. Parent partner peer partners with lived experience are very often trained to act as intake coordinators. Social workers may be mandatory reporters, but in many jurisdictions, that obligation is relieved where they are part of this formal legal team. And where mandatory reporting continues to be an issue, even if the social worker is a member of the legal team, some programs have been using individuals who are educated as social workers but are not fully licensed, thus relieving mandatory reporting concerns. We've also seen that some programs, such as Legal Services of New Jersey, utilize social work interns in their program, and at that program, they have a protocol for reporting to the lead attorney before the filing of a mandatory report. And what they've seen there is that none of the social work interns have ever filed a report under that protocol. So let's move then to holistic representation. CPS investigations, homelessness, addiction, consumer abuse. Due to poverty, our clients rarely experience traumatic challenges one at a time. They experience many, all at once or in rapid succession. So utilizing our example from the beginning in our sort of sample fact pattern, mom, we know, needed help securing safe and stable housing for her family. She was interested in getting substance abuse treatment because she had developed, a drug habit or had relapsed in the face of the stresses of eviction. Mom was also looking for counseling for herself and her children. And then we also had the CPS investigation to deal with, and mom was in need of legal representation to advise her in the CPS investigation. So through robust intake, we examined the entire family, and we would take a look at all of these needs. We would use releases of information to ensure that effective communication and access to information between the multidisciplinary team and the department. Holistic representation also means asking about everyone in the home and seeking to fully understand the family dynamic. Holistic rep requires listening to clients and believing what they say about the most pressing issues they are facing instead of substituting our own judgment for theirs. We can only be effective in our work if we develop trusting relationships with our clients, and that requires that we respect them as experts in their own lives. Moving then to effective community partnerships. I think that the saying, it takes a village, is quite appropriate here, right? Organized community is the only means of affecting long-term change for our families. So looking then at some of the common community partners, schools and daycare centers. So a couple of opportunities here. First, schools can be an excellent opportunity for place-based models, meaning models where we actually integrate those programs directly into the school system. Maybe that's through a multidisciplinary office there within the school building where families are. We've noticed that utilizing the place-based model, there are programs like, for example, Standing with Our Neighbors in Atlanta, Georgia, which is now integrated into 9 Atlanta inner city schools. And what they found was their presence in the school system and being where their clients are provided a great opportunity to begin to build community trust and confidence, which is certainly important in being able to actually serve the needs of the community. We also see an opportunity with family resource centers and other, family community centers. These community centers, again, speak to that idea of serving families where they feel safe. And they also provide a great opportunity for outreach if you are interested in doing know your rights advocacy and in doing programs to educate the community on the child welfare process. We find that community centers and FRCs can be a great partner in that. And then we have churches and faith-based organizations. So programs that are really doing a great job of serving holistically their families' needs often rely on churches and faith-based organizations to provide resources for basic needs and then community-driven supports. And again, they're also an opportunity for that sort of know your rights outreach and community engagement. And then we have our general service providers that are working either through public health departments or with the child welfare agency. The idea is that by partnering with these service providers, we seek to understand the mechanisms through which those services are available so that we can ensure warm handoffs and ensure that we are utilizing all of the resources at our disposal to serve our families. One common question we encounter when we talk about working with service providers or community centers and these other resources is, aren't we just providing the same services that the department is supposed to be providing? And there's a great sort of response to that, which is, when education, healthcare, mental health, and social services systems channel families to state surveillance that threatens child removal, they may distance families from the systems tasked with assessing them. So predicating assistance on involvement with the child welfare system means that we have subjected, again, the family to that child welfare system involvement sort of unnecessarily. Why wait until it's necessary to engage the child welfare system before getting families the help they need? I would also note that department involvement is often a source of trauma for our families. So when we, again, predicate that access to legal and social support services on the department, we leave our families vulnerable to those unintended consequences. So another big piece that people always ask about, common funding sources. So much of this sounds good, but how do we pay for it? So in October of 2022, this is again hearkening back to that survey I mentioned earlier, we surveyed the 30 existing and emerging PLA programs participating in that national PLA cohort. And these programs reported funding from the following sources. You see, I've tried to break that down in a way that's a little bit accessible. What we found on this survey is, state funding and private foundation grants remain the most common funding sources for PLA services. That said, 70% of our programs rely on more than one funding source. So most programs are not getting all of their funding from one place, and they're having to diversify. I think it makes sense. We are taking a sort of community-driven approach, and so we're going to have to get creative with our funding sources. But as we see here, TANF, CIP grants, VOCA, ARPA funds, to a large degree private foundation grants and private donations, and then state and local funding. All of these can come together to support these preventive legal advocacy programs. So, with the fundamentals in place, now it's your turn. How can preventive legal advocacy be implemented to benefit families in your community? what I would like you to do is take out a blank sheet of paper and list one specific unmet legal need that commonly affects the families you work with. Thinking about the specific legal issue you've selected, discuss the following questions and write your answers down on your paper. First, would resolving this legal issue for families in your jurisdiction help to prevent removals? I think the answer should probably be yes, because preventing just about any legal issue is going to add to family stability. But in answering this, kind of consider why. Think about how the issue that you've selected, the common legal issue that you see your families face, how does this contribute to their child welfare system involvement? Turning then, taking it a step further. So based on what we've discussed today, do you think this legal issue could be addressed through preventive legal advocacy? I would ask why or why not, but I'm not really able to address your why nots at this time, since this is sort of a pre-recorded presentation. But I want you to think about it. If you have questions as to why it may not be able to address those issues, really think through that and break it down. I would argue that in the vast majority of cases, the legal issue could in fact be addressed through preventive legal advocacy. And with that being said, I think it's important to consider what a preventive legal advocacy program to address this issue would look like. So still writing answers down on the piece of paper, the first step would be to kind of consider the program model. And what I'm going to do here is kind of flash back to the slides that address each of these topics so that you can look at them for reference, and then feel free to pause the presentation so that you can sort of look at the slide, look at the information that's been provided, and then write your answer. So considering then program models. And again, these aren't a one-size-fits-all. There's no reason why a program would have to fit tidily into one of these categories, but these are sort of the 5 broad categories. So which of those may make sense given the legal issue that you've identified? And then once you've sort of sorted that out, turning then to referral sources. Taking a look at this list, you would be familiar with the organizations in your community, and with the given the legal issue that you've selected, sort of which ones of these referral sources that we generally see utilized may fit for your program in your community. And then team members, we know we have 3 key types, but there may be some others you have in mind. When it comes to the parent partners with lived experience, there are various organizations in different jurisdictions that are utilizing individuals with lived experience to influence the child welfare system. So you may be able to drill down and be really specific about, what organization you could pull parent partners from. And when I say pull them from, I don't mean hire them away from, but sort of who would you talk to in trying to look at that and trying to bring on a parent partner? Where could the attorneys come from? Who may be a good fit if you're able to be that specific? Social workers, same thing. Is there a school? Is there a group that you could utilize for this? What might that look like for you? And then back to issues for holistic staffing. Kind of given the legal issue that you're looking at addressing, what sort of holistic staffing needs do you think your team might be encountering? So if we're looking at custody issues, for example, what are sort of the common things you see? I see, counseling can be a big issue in a lot of those disputes. There's going to be tangential issues. So I guess what I'm asking here is for you to think through what tangential issues the family, sort of this fictive family in your mind who has this legal need, what kind of issues may you be commonly addressing in trying to meet that legal need? And then, of course, community partners. In light of the community partners that you think might be available in your jurisdiction, what organizations could you see teaming up with if you were to try to create a program like this? Where might be good places to reach the potential clients, the people who you think have this legal issue or set of legal issues? What kind of effective community partnerships do you think you could tap into? So once you've sort of outlined those things, I would ask, if a program like the one you've envisioned existed in your jurisdiction, how might you personally support or interact with that program given your current role? So I'm not sure who's actually watching this presentation and what your role is. Presumably you are somehow involved in the child welfare sector. I think that what we find with preventive legal advocacy programs is everyone has a role. Everyone can help, right? So whether you're a court administrator thinking through what this might look like in your jurisdiction, or you're a child welfare attorney, or you work for the agency, or you're a case manager, what would your personal role be? How do you interact with these programs, this kind of fictitious program that you're envisioning? What would your role in that be? And again, this is not exclusive. If you work for the agency right now, then your role may be in educating other case managers in your office about this program, in working to collaborate productively with the program. Perhaps you're a third-party provider or provide services for the agency. And in that case, it may be being a productive referral source for a program like this in your community, or educating your clients about these services. There's a number of different ways to think about this. Now, once you've kind of worked through that, since we're not in person and I can't take questions and we can't really delve much further into it, I just want you to set that sheet of paper aside and keep it in mind as you move forward and begin to learn more about preventive legal advocacy, and thinking through who might you talk to if you're interested in starting a program like this. What involvement could you have in that process of implementing something like this in your jurisdiction? So with that, we'll move to some preventative legal advocacy takeaways. And these are actually quotes that I pulled from a wonderful article recently published by the American Bar Association. And that article was by Katie Jo, Sarah Cook, and Hillary Cushions. The title of the article was Cornerstones of Interdisciplinary Prevention Advocacy. And I think they made some really excellent points in that article. So I've pulled those here to serve as takeaways. So the first would be, when families have the resources they need to thrive and the ability to receive natural support within their community, the children are the ultimate beneficiaries, as they can remain safely with their family and community. Also, the primary legal objective is to avert court involvement and the removal of the child, but a family's entanglement with the child welfare system often stems from a myriad of underlying causes. Preventing such entanglement necessarily requires engagement with the underlying causes. Preventing child welfare involvement looks different for every family. Thus, preventive legal advocacy programs must be open to a broad definition of client engagement and define success beyond preventing a removal or the filing of a petition. Staying rooted in community means meeting clients in the spaces where their lives happen. That'd be their homes, their neighborhoods, their workplaces, their schools, their meetings with their probation officers and social workers, and so on and so forth, right? It's getting involved in the family, in the community, and serving them where they are. Prevention and pre-petition programs are committed to fighting poverty and racial inequity, which are the most significant predictors of child welfare involvement. So our programs must aim to support families as they navigate the challenges of poverty. I would note, kind of in closing, that there are a number of national endorsements for PLA. These are just a few. The Children's Bureau, through a number of memorandum that they've put out in the last couple of years, have been very supportive of the concept of upstream civil legal advocacy to support families and safely reduce child welfare system involvement. The Family Justice Initiative also does some great work in this space and have some great resources on their websites. The ABA and NCJCFJ have released resource guidelines, including those on pre-petition representation, and you can find those through a quick Google search. And then Casey Family Programs, who I would note also supports my work as the Preventive Legal Advocacy Fellow, but they have some wonderful resources on their website, including a Preventive Legal Advocacy resource page, which can be found at that website listed below. So here is a copy of my contact information. As I noted, I would encourage anyone who is interested in learning more about preventive legal advocacy to reach out to me via email. I would be more than happy to add you to our preventive legal advocacy cohort. And as noted, we host monthly meetings. We have a shared resource drive. That contains a wealth of information concerning preventive legal advocacy and pre-petition programs. And all of that is resources I would be happy to make available to anyone who's interested in learning more. So thank you very much for taking the time to watch this presentation. I hope it's been beneficial in at least laying the foundations and giving you some guidance on the fundamentals of preventive legal advocacy, and hopefully getting the wheels turning on how preventive legal advocacy could be implemented in your own community to meet family need and support families. Thank you very much.